machine. Everybody, jump somebody.
We starting. We starting.
You know what to do now. Ain't nobody better than we. Everybody know it. We turn over places. It's like we own it. And we ain't watching faces. If the police coming, security coming. Is he saying nothing?
What's about the appearance there? Since being there, one should go by your cash out over the prison. Cash out.
July sun, this is my story, this is my glory. Yeah, with you, I write my story, I find my glory. Yeah, Hiram, it's only you, it's only you, it's only you. Yeah, Hiram, it's only you, it's only you, it's only you.
This is our island,
Our people.
our beer.
Hyrule is Carnival.
Welcome and good afternoon to this Sunday's edition of Asbot News Network on the Spot program. My name is Sion Marshall, and I am standing in for the brother Marlon Joseph, who is unable to be here with us today. I hope I can fill Marlon's shoes, very huge shoes. Just so you know, I'm a regular host of the Thursday night late night program Uplate with Sion Marshall. You can find us right here live on Facebook as well. Our website is www.uplatewsm.com, and you can look for us on Facebook as Uplate with Sion Marshall. This afternoon's program, we are dealing with the issue of the Caribbean Court of Justice and whether or not St. Vincent and the Grenadines should move towards having that court as its final appellate court. To discuss this today, we have a very knowledgeable panel, which includes Keswin Walters, attorney at law, Jomo Thomas, the Speaker in the House of Assembly, and Philbert John, civic educator. Over the last few days, and with the appointment of the Honorable Adrian Saunders as the President of the CCJ, there has been a lot of debate, renewed debate, about whether or not St. Vincent and the Grenadines should adopt the CCJ as its final court of appeal. You would remember that this debate occurred back in 2009 with the proposed constitution. There was quite a lot of debate about it. Since that time, it has died. But with the appointment of, or the election of Justice Saunders as the president of the CCJ, and with that ceremonial sitting being held here, it has rekindled and reignited that debate. Today, we go through the entire issue. And as I said earlier, we have a knowledgeable panel. I'm going to allow the panel to give their opening thoughts on the issue before we get into the meat of the matter. So we'll start with the person closest to me, Keswin Walters. Keswin, good afternoon.
Good afternoon, ladies and gentlemen. Well, I am no stranger to the Vincent and the Grenadines populace. I'm a Crown Counsel in the Chambers of the Honorable Attorney General. I'm also the President of the Unity Youths of St. Vincent and the Grenadines. But I must say that the views which I will espouse today are my own and not representative of the government of St. Vincent and the Grenadines or of the Unity Labour Party. I'm no stranger to the Caribbean Court of Justice. I've been involved in the debate since the 2000s. I was involved in a lot of the consultations pre the referendum in 2009. I remember back in 2003 we spoke about this at the North Union Secondary School in one of the consultations hosted there by Bertram Commijon QC, and in all through my undergraduate studies at the University of the West Indies, the Caribbean Court of Justice was quite central to the debate there, being established in around 2005 in Trinidad, and all of the Caribbean countries, all of the CARICOM states would have acceded to the original jurisdiction, and lots of discussion would have centered around that. But only two initially would have acceded to the appellate jurisdiction, and there would have been much more debate about whether the remaining CARICOM countries should accede to the appellate jurisdiction. So we're here today to discuss our own personal views, I would believe, and as we get later on into the discussion, you will know where I stand for our guest.
Thank you very much, Kezran, for that disclaimer. And I noticed that disclaimers are flying left, right, and center. We move on to Mr. Jomo Thomas, Jomo Sanga Thomas, who is currently Speaker of the House of Assembly here in St. Vincent and the Grenadines. Jomo, good evening.
Yes, indeed. Good afternoon. I am Jomo Thomas. I currently hold the office of the Speaker of the National Assembly here in St. Vincent and the Grenadines. I am a journalist by training. I am a lawyer by profession, and I am a well-known contrarian in St. Vincent and the Grenadines. I must say that I have long been a supporter of the sovereignty of St. Vincent, the sovereignty of our Caribbean civilization. I have long believed that the Caribbean should be one Caribbean, it should have one jurisprudence, it should have one system of justice. I think one of the biggest failings of Caribbean societies is the fact that the West Indies Federation collapsed and failed, and I would like to see even further and closer unity, which means that I am a firm supporter of regionalism, and I am an opponent of any system that allows for outside interpretation of our policies, our laws. So in that sense, I do believe that the Caribbean Court of Justice is the final piece to the puzzle of the total reclamation of our sovereignty and our independence.
Thank you very much, Jomo. I know you touched on two issues that I hope later on we can delve into: the issue of sovereignty and also the issue of the outside interference of the CCJ. Interesting concept, and I really hope that we can touch on those later on, because while the issue of the Privy Council may seem to encroach on our sovereignty, there is a school of thought that regionalism generally encroaches on sovereignty, and that is one of the reasons, one of the problems that the EU has, where some member states of the EU believe that the ECG and other bodies of the EU encroaches on sovereignty. But we will get to that hopefully a little later on. Finally, my former teacher and also contrarian, Philbert Judd. Philbert, good afternoon.
Yes, good afternoon, Sian, and good afternoon to all the persons locked on to this show. Let me begin by congratulating Asbot for this initiative. It's innovative, it's different, and I want to wish him all the best and encourage other persons to look into similar initiatives. I know, Sian, that you have something that impresses me too.
Thank you.
I don't know why you call me a contrarian. I don't even know the meaning of the word. So
Well, I just used it because Jomo used it. Is that okay?
Okay.
Okay.
I'm here as a citizen who happens to be an educator, and I've asked the producer to list me as a civic educator because I have an interest in educating the populace about civic issues, and our court system happens to be one of those civic matters that we need to deal with. A couple things I want to say before we continue the discussion. One, like Jomo, I'm a firm supporter of the Caribbean Court of Justice. From the time a regional court was brought to my attention way back in the St. Vincent Grammar School, I had support the idea of any kind of system to replace the Privy Council. The second point I want to make is that I'm of the impression that the panel assembled here right now, we all may share similar views in that regard, which is unfortunate because I was hoping to meet someone here who have a different view. But here what the problem is. They're going to listen to us, those who have different views, then they're going to go to Facebook and lick us up for expressing that view. But none of them had the, what was the word again? The guts, the intestinal fortitude to come here, or the gonads to come here and debate the issue. Because there's a debate going on, and persons who claim to be nationalists, patriots, etc., I'm still trying to figure out why they still have this barrier, put up barriers to St. Vincent and the Grenadines signing on to the CCJ in its appellate jurisdiction. So I'm hoping that by the end of today's discussion that we should educate our listeners as far as possible and encourage them to think favorably about St. Vincent accessing the CCJ in its appellate jurisdiction.
All right, thank you, gentlemen. Also, Pigeon, while the panel may share similar views, you do not know the view of the moderator. So you just may have someone moderating the show who is of a different view. One doesn't know. So let's see how this afternoon goes. All right. Now, as I listen to the debate that has happened over the last couple of days, it is clear to me that there is a lack of information regarding exactly what the Caribbean Court of Justice is, based on some of the criticisms that I've heard and some of the reasons put forward that prevent individuals from supporting the St. Vincent and Grenadines from signing on the court in its appellate jurisdiction. Now, Keshawn first mentioned it, and you've mentioned as well. So there are two jurisdictions of the court. Let us start there in explaining to Vincentians, those looking at us, the difference between the original jurisdiction of the court and whether or not St. Vincent and Grenadines is, that court has jurisdiction over St. Vincent and Grenadines and whether we use it. And then we would move on to the appellate jurisdiction, which seems to be where the big issue is. So there's no problem, it seems, or people may not even know. Because without being long-winded, the discussion seems to suggest that St. Vincent and Grenadines isn't a part of the CCJ. So first of all, are we?
We are a part of the CCJ. We have acceded to the original jurisdiction.
What does that mean?
Of the CCJ. All countries which are a part of the revised Treaty of Chaguaramas have acceded. All countries which have acceded to the revised Treaty of Chaguaramas have acceded to the original jurisdiction of the CCJ, to the extent that the CCJ has the purview to interpret all provisions of the revised Treaty of Chaguaramas and its application to all of the member states. For example, there may be a dispute between Trinidad and Guyana. I know that there was a dispute between Trinidad and Guyana over cement, TCL Company Limited, and the Caribbean Court of Justice would have determined that case because, for example, within all of the CARICOM countries, the aspiration is to have free movement of goods, of capital, of people, etc. We all know of those four things which it is desirable for there to be free movement of within CARICOM, so that the CARICOM member states will be able to develop economically and otherwise. So, for example, the Shanique Mairi case as well brings to the fore the issue of free movement of people. We all know that Miss Mairi tried to go to Barbados from Jamaica and was met with some unfavorable circumstances, and she was expelled and returned to Jamaica. And the Caribbean Court of Justice would have also determined that case there, and it would have determined that CARICOM nationals have the right to travel to another CARICOM country, and you should be automatically landed for 6 months, subject to certain conditions, because each state must preserve the territorial integrity of their country. So all CARICOM member states have acceded to the original jurisdiction of the Caribbean Court of Justice as it regards the interpretation of the revised Treaty of Chaguaramas. which all CARICOM member states have acceded to.
Now, you just mentioned some judgments, and there are many more. But I think that is, I think without getting into specifics, I think that is what I want to spend a few moments on, because I don't want people thinking that, oh, Barbados and Jamaica signed on to the CCJ, so that's why that happened.
Yes.
You know?
Well, Jamaica's not signed on.
Well, I'm saying, but they may not know
To
that.
the original jurisdiction.
In the
Right,
in
that's
the
the
appellate
point that's the
jurisdiction,
point I'm
yes.
making. So the point I'm making that without going forward and with people not knowing, they may just assume that maybe those two countries have, as it was, signed on to the CCJ, but we have not signed on, because that is the language you hear all the time. St. Vincent and the Grenadines signing on to the CCJ. I think the Latin term being used is ipso facto, which basically says just by the mere fact of you being a member of CARICOM, the CCJ has original jurisdiction
Certainly.
over you. That's the case. That's the case,
Yes.
Jomo?
Well, that is the case as it relates to the interpretation of the revised Treaty of
Of
Chaguaramas and
Chaguaramas.
anything that comes
Yes.
as a result of that. I think that what we need to know as the world is that the CCJ, there are a number of issues which have come up over the years.
Absolutely.
And all of these countries, as Kezran correctly said, all of them in CARICOM are part of the original jurisdiction. The countries that are part of the appellate jurisdiction are Belize, Guyana, Dominica, and Barbados. Those are the ones that have acceded to
Go over
the
that list again. The list of countries.
Belize, Guyana, Dominica, and Barbados. Those are the four. The question now is to how we get the other countries to move to that point.
Right. So
And just to note that
yes.
sign on to the original jurisdiction was compulsory as a result of once you're party to the
that's the point.
treaty.
So it's beyond compulsory. It's just, as I said, ipso facto.
There's nothing you could do about it.
Right. Just simply because you're
All CARICOM countries
All.
have
Simply because
acceded
you're treated
to the Caribbean Court of Justice to interpret the revised Treaty of Chaguaramas.
Absolutely.
And that is what I think is centrally important for the understanding of the people of our country.
Absolutely.
Because we, all of us, all 14 CARICOM countries are members of the CCJ.
Absolutely.
As it relates to the
its
original
original jurisdiction.
jurisdiction. Only four. Belize, Guyana, Barbados, Dominica. I know there's a movement now to try to see if we can get, Grenada is making an effort to go on, and
And it's an appellate jurisdiction.
Yes, in the appellate jurisdiction.
Right. So let's just make that clear that we've established that St. Vincent and the Grenadines is a member of the CCJ, has acceded to the CCJ in its original jurisdiction. And that means, based on my research and the comments of our learned friends, that any country or any individual who feels that St. Vincent and the Grenadines has infringed on any of the articles of the Treaty of Chaguaramas can take St. Vincent and the Grenadines to the CCJ, and we will be made to answer.
There's one other thing that we need to make, the point that we need to make. By virtue of the fact that all of the countries have acceded to the original jurisdiction, an individual who wants to bring a case to the CCJ cannot simply bring the case, because it is the states that have acceded.
Right.
So what needs to happen, for example, if let's say somebody comes to my law firm and say, look, I went down to Trinidad, the Trinidadians threw me out for no clear apparent reason. My firm would need to write to the Ministry of Foreign Affairs to say, look, here's the difficulties that my client has, and we want you to raise this issue with the government of Trinidad and Tobago, or whichever other government
Right.
within CARICOM. If the government can either decide to take the issue as a state, or the government can say, look, we don't want to take this as a state, but we have no difficulty with your firm representing that individual in doing the work. It's like, it happens a lot with the United States. An American citizen goes abroad, the American citizen gets arrested for whatever reason, or gets in contradiction with the law. The first thing that is required is for that American citizen to contact the U.S. Embassy, and the U.S. Embassy may try to make certain representation for that person. In this case, as it relates to the CCJ, the individual, the lawyer who wants to bring a case on behalf of an individual must first contact the Ministry of Foreign Affairs to say, our citizen has been the rights of our citizens has been infringed upon, and we intend to bring a case, but ideally we would like the state of St. Vincent and the Grenadines to bring the case or to enter into negotiations with the government of whichever contravening country will be identified.
Now, interestingly, a number of countries have taken cases to the CCJ
Yes.
since its establishment. I don't know, unless Jumo and Kezran could correct me, I don't know if St. Vincent taken any case arising out of the original jurisdiction. However, there's an issue right now, and I'm surprised that I haven't heard the CCJ being invoked to address it. That is the issue with the traffickers in St. Vincent and their inability to get financial resources out of Trinidad, the foreign exchange issue. And I'm a bit surprised that I haven't heard anyone in officialdom, and the person who tend to speak on this matter most of the time is the Prime Minister. I haven't heard him threatening in any way to invoke the involvement of the CCJ to address this issue. But that, to me, strikes me as an example of an issue that we could use for the original jurisdiction in St. Vincent of the CCJ.
I actually thought of that, you know. It would be a good way for us to wade into the waters of the CCJ in its original jurisdiction. But
Right.
I've also noted that the government has taken some measures by which they would restrain outgoing foreign exchange to Trinidad and Tobago, since Trinidad and Tobago has limited foreign exchange which can come to St. Vincent and the Grenadines. There has been some exchange controls placed on foreign exchange going to Trinidad and Tobago. I note that all transactions which have to be done with Trinidad and Tobago now have to be done in TT dollars. You wouldn't notice it, the common man wouldn't notice it, but if you are sending a wire transfer to Trinidad and Tobago, you wouldn't send 50,000 US dollars anymore. You would send whatever the equivalent is in Trinidadian dollars because of the exchange controls. So if we can't get US dollars out of Trinidad and Tobago, then you can't get US dollars from St. Vincent and the Grenadines. The situation is dire in Trinidad, yes. Their foreign reserves are low, but if we continue in this vein, our foreign reserves will also be low. It's an alternative remedy, so to speak, to actually going to the CCJ. Although it would be
One that
interesting.
incite some sort of conflict, possibly.
It may
Trade war, maybe.
it may deepen the problem. It may cause some responding exchange control from Trinidad and Tobago or some other measures. But for now, it's the government's best bet of an alternative means.
I'm not even sure whether what kind of trade war could there be between Trinidad and St. Vincent. The exchange between Trinidad and St. Vincent, the amount of in dollars, the amount of exchange is Trinidad outstretches St. Vincent by a tremendous thing. So
they stand to lose more than to gain with any.
Well, I don't think so, because we need the things that Trinidad has. I'm not so sure that Trinidad don't really need our bananas. Trinidad could get bananas from Suriname. Trinidad could get bananas probably from St. Lucia. So they don't need our bananas. But we need their cement. We need their steel.
But that is exactly.
But that is why I was making the point that there are two things and there are two tracks here. Certainly, I think the government of St. Vincent and the Grenadines has decided to use diplomacy to see how it can be resolved. But I agree with Kezran that one of the things that we need to do is probably to test it at the CCJ.
Exactly.
To have a because it wouldn't only work for us. It would not set down the ground rule just for St. Vincent, Trinidad. It would set down the ground rule across CARICOM. And there's nothing to me that explains why a trafficker goes down to Trinidad, sells $100,000 worth of goods, and then can't get the money out. because it defeats, it puts a bottleneck in our system, and in many respects gives many of our traffickers a bad name, because our traffickers may pick up some things from Kezran's dad, from your uncle, from Miss Tina, from Miss Doris, and when he comes back and said he did not get the money, suspicions begin to develop as to whether this trafficker is not really playing the fool, is collecting the money and trying to hold on to it.
Right.
But I think it's now in the public domain that there's a real problem in terms of getting the foreign exchange. So it's a beautiful issue to test at the Caribbean Court of
So
Justice.
to the extent that St. Vincent is aggrieved, the CCJ is a source of remedy.
Right.
And as Jomo rightly points out, the remedy could be applied across the board once the case is heard and a decision is made by the sitting judges.
Interestingly, it's a similar case that was made against the Trinidadians by Jamaica maybe about 2 to 3 years ago. The Jamaicans claimed that Trinidad is practicing unfair trade practices to the extent that for every dollar worth of goods exported to Trinidad and Tobago from Jamaica, Trinidad exports $23 to Jamaica. And they alleged that in Trinidad there were some unfair trade practices that would prevent the Jamaicans from exporting as much to Trinidad and Tobago and from selling in their supermarkets, etc. So this shows the kinds of disputes which can come before the CCJ, and particularly with regard to trade. And as I said before, movement of people, movement of capital in regards to the movement of monies around the region. But we must also remember that in particularly regarding the common external tariff, this might prevent a trade war, because we cannot impose a tariff on goods coming from Trinidad and Tobago. Trinidad and Tobago cannot impose a tariff on goods coming from us.
There were cases between Guyana and Suriname, and between Trinidad and Suriname, where tariffs and in this case environmental levies were put on drinks bottles.
Yes.
And one company out of Trinidad that had a subsidiary in Guyana did take that Guyana to court in its original jurisdiction. And we can get into some of those a little later on.
Yes.
But I think having established that St. Vincent and the Grenadines is in fact has in fact acceded to the CCJ in its appellate jurisdiction, original jurisdiction, we then get to the crux of the matter.
Yes.
The crux of the matter is the difficulty with our country taking the other step and acceding to the court in its appellate jurisdiction. And by appellate, I think we mean that it will be the final court of appeal replacing the Privy Council. Now, before we even get to that, though, isn't our High Court a regional court?
It is.
Well, regional as it relates
As it
to the Organization of Eastern Caribbean States.
I would suggest that either Jomo or Kezran outline the court system in a simple way, so we can understand where the CCJ will be situated.
That's
should there be the
exactly
change.
why I'm starting with this question, because when we go to the High Court, is that a quote-unquote national court in its truest sense, or is that a regional court? And if it is, what difficulties have we had with such a regional establishment as lawyers?
Well, I think many of our cases may start in the magistrate court.
Right.
And in fact, the magistrate court decides about 90% of all of the disputes in our system. There are a number of matters, for example, property matters are not heard in the magistrate court. Matters that involve monies over $15,000 are not heard in the magistrate court. So once these matters are brought, they're brought in the High Court. And the High Court in St. Vincent, what is sometimes called the Court of First Instance,
Right.
is part of a regional court. It is the St. Vincent, the Supreme Court Act, Eastern Caribbean Supreme Court Act establishes that court. So you have a High Court of St. Vincent, you have a High Court in all of the other OECS countries. The matter begins there. And if a particular party is aggrieved, that party may appeal the matter to the Eastern Caribbean Court of Appeals, which is headquartered in St. Lucia.
Right.
If that matter is decided in St. Lucia and the party one of the parties or both of the parties are still aggrieved, that matter could be appealed to the Privy Council, which is currently the highest court.
So let's not jump to the Privy Council just yet. I think I want, because you see, here's the thing. Based on the discussion, the impression may be given that the CCJ is possibly our first attempt at getting into a regional court. And so some of the discussions you hear about political interference of judges and so on and so forth, because governments are paying for the court and all of those things, are reasons why people wouldn't accede to the CCJ in its appellate jurisdiction. How is it different with the Eastern Caribbean Supreme Court, Court of Appeal?
That's the thing. I don't see much of a difference because the judges,
in terms of its composition,
etc. Well, in terms of its composition, the CCJ is composed of 5 judges. The Court of Appeal, their panel is comprised of 3 judges, but in the High Court, you would only have 1 sitting judge. But the Court of Appeal and the High Court are is a regional court.
How are they funded?
Well, they're funded by the member states.
Because and we're going to take a break.
Just like the CCJ.
So remember where you are. We're going to take a break. But I think what I'm trying to do immediately is establish, if any parallel whatsoever, between our court of first instance or appeal court, and then we move on to the CCJ. We take a break, and when we come back, we discuss more of the CCJ and whether or not St. Vincent and the Grenadines should accede in its appellate jurisdiction. Don't go away.